We have one case this morning set for video oral argument, which is State of Ohio versus David Stultz. Both sides will have 15 minutes to argue. If you're the appellant, you may reserve up to 5 minutes for rebuttal. If you could let me know when you get started, if you'd like to reserve any time for rebuttal. I'm going to be keeping the clock this morning. Whether or not it's relevant to here, we always caution everyone that we don't use the names of victims or minors in oral argument. We are streaming live on YouTube. When you are not speaking, if you wouldn't mind muting your microphone so that we don't have any background noise coming in when opposing counsel is giving his oral argument. We have read the briefs and we are ready to proceed when you are.
Very well, Your Honor. I would like to reserve 5 minutes if I may.
Certainly.
Thank you, Your Honor. Your Honors, may it please the court. My name is Attorney Jason Harless. I represent David Stultz in this matter. David Stultz was convicted at a jury trial of operating a vehicle under the influence. Prior to the trial, there was a motion to suppress filed. My first assignment of error addresses the motion to suppress, and Officer Tippett's lack, in my opinion, of reasonable suspicion and probable cause to arrest Mr. Stultz in front of his home. Following the suppression hearing, it was learned that two officers responded to the OVI, Officer Tibbetts being the officer that responded directly to the property owned by Mr. Stultz, which in the driveway was located the vehicle that was identified by a named witness. Your Honors, in the motion to suppress hearing, the named witness did not testify. There was some testimony given that the second responding officer responded directly to the witness who had followed Mr. Stultz's vehicle to almost near his home, but not directly to his home. I believe there's some pictures in the record that will show that the line of sight from where the witness was obscured, and testimony elicited at trial will show that the witness could not clearly see both sides of the vehicle, nor could she see all of the doors, as she incorrectly identified that there was only one vehicle in the driveway when there were at least two vehicles, both of substantial size. At the suppression hearing, the trial court focused primarily on whether or not the tip was reliable. Now, I understand that obviously there's much case law to do about whether the reliability of an informant, what kind of weight it carries and how much weight that has, and as a trier of fact, that's up to the trial court to determine. However, in this matter, the record will show that even assuming that the informant's tip was accurate, no information was given about the number of occupants of the vehicle, nor could the witness identify the driver of the vehicle himself, only that the vehicle, which was registered to Mr. Stultz, returned to Mr. Stultz's property, and that the witness stopped some distance up the street. That said, I would urge the court to find that the trial court erred in denying the motion to suppress, because as I stated, the court made no inquiry as to who was in the vehicle, or made no finding rather into who was in the vehicle, or whether or not the witness could accurately identify who was driving the vehicle, or even if there was an additional party in the vehicle. With respect to my second assignment of error.
So before you move on to your second assignment of error, I just wanted to double check with you. You're solely alleging that there is no probable cause for the arrest. You're not necessarily alleging that there is no reasonable suspicion for the stop.
Primarily,
yes.
It
wasn't a stop. I understand that it was in the property, but you're just looking at the arrest itself.
Right, and mostly because of the fact that the vehicle was stopped, in fact, backed into the driveway.
In the driveway.
Right, and I believe the evidence will show that the vehicle, which is a Escalade ESV, a large vehicle, 19 plus feet in length, was properly backed into the driveway, not in an obscure manner that would indicate any level of intoxication. The officers did testify that it was, I believe, Tippett's words were fairly straight at trial. Again, moving on to the second assignment of error, the prejudicial video that was showed at court. During the court trial, I had objected several times to the video being played of my client in the back of the police car due to the prejudicial nature. In fact, the trial court, in its denial of the motion to suppress, characterized Mr. Stultz's behavior in the back of the vehicle as a long, nonsensical tirade. I believe that shows that the court was well aware of what was in that video and the propensity that would have to skew a jury, or make it be prejudicial, highly prejudicial to my client. Again, I offered to stipulate with the state. The state denied that stipulation, and I was asking again repeatedly to stop the playing of the video, even after a minute or two of the video playing. However, the court continuously denied that objection, permitted the vehicle to play, or the video to play rather. I would also urge the court, as it considers this second assignment of error, to listen to the recordings of this trial. I believe that the trial court shows some level of disdain for my client, and I believe that was transferred to the jury and showed prejudice really against my client. Again, the manner he was acting, I understand, was indefensible. There's no reason you should speak to an officer in that way. My client apologized for that behavior. However, showing that video to the jury served no purpose other than to prejudice the jury against my client. Again, the court itself had viewed the video at the suppression hearing and classified or termed his conversation or his speech with the police officers as a long, nonsensical tirade. And I think that again shows the court acknowledges that was going to be a prejudicial video with relatively low probative value. Again, I offered to stipulate to the fact that he was intoxicated. It was apparent my client was intoxicated from the beginning, and we would ask that the court find that there was absolutely prejudicial video played with very little to no probative value. Furthermore, under the second assignment of error, I believe that if the court listens to the transcripts or listens to the trial, it will hear the consistent objections that either were sustained and the state persisted with the line of questioning without any redirection from the trial court. And I believe that overall, the trial court's attitude towards my client shows that there was a clear prejudice, and I believe that was again transferred over to the jury. With respect to my third assignment of error, the manifest weight argument, again, my client was stopped in his driveway. Stopped, I guess, is a different term in this context. He was allegedly seated in the driver's seat with the door open and the radio playing when the officers arrived on scene. Testimony at trial and at the suppression hearing will show that the garage door to my client's home was open. The lights in the garage were on, none of which were things that the witness who testified, the 911 caller, Miss Entwistle, had identified at trial. Again, it's my contention that there was no possible way Miss Entwistle could identify Mr. Stultz driving the vehicle, the number of occupants in the vehicle, whether or not anyone got in and out of the vehicle, based on her inability to see, again, the second large vehicle in the driveway, which shows that there was no possible way she could have seen who could have gotten in and out of the vehicle, especially the passenger side of that vehicle. Again, Your Honors, I would ask that the court find that this conviction was against the manifest weight, as Mr. Stultz at no point was seen operating the vehicle. Again, sitting in the driveway, backed in, radio on, doesn't amount to operation of the vehicle. Additionally, as the jury was considering the case in deliberation, about 30 to 45 minutes into deliberation, the jury returned a question of at what point does a defendant operate a vehicle? And I believe that shows that the jury believed at the time that no one could identify Mr. Stultz operating that vehicle. The court, after a short hearing on the record, returned with the standard definition of operate, to cause to have moved, or to have moved, or cause to have moved. Shortly thereafter, they returned that guilty verdict. And I believe that the jury, again, with the prejudice from the showing of the video and the inconsistent rulings on objections lost its way, Your Honors. And I would ask again that this court find this conviction is against the manifest weight, and I will reserve the remainder of my time for rebuttal, Your Honors.
Thank you, counsel. You'll have 5 minutes for rebuttal.
Thank you.
Counsel for the appellee.
Good morning. A couple of comments that Mr. Harless made aren't even assignments of error. Disdain or prejudice that the court allegedly demonstrated towards his client or prosecutor's conduct. I don't think those fall into the category of any of the 3 assignments of error that the appellant has made. But as it relates to his first assignment of error, probable cause, not reasonable suspicion, Hillary Entwistle and her friend Brandy followed Mr. Stultz from Avon all the way into Avon Lake, were reporting to Avon and Avon Lake police departments contemporaneously as they were following what turns out to be Mr. Stultz. They follow him directly to his driveway. They wait a few houses down the street, and it was very clear from the testimony. Well, at the suppression hearing, the police officers indicated that when they passed the car that the 2 young ladies were in, they could clearly see the vehicle at the end of the street. The police officers pulled up to the apron of the driveway where Mr. Stultz had backed in his car. I believe there was some conflicting testimony as to whether or not he pulled in evenly or not, but nonetheless, he backed into the driveway. Police officers immediately notice that Mr. Stultz is highly intoxicated. He's totally inappropriate in his commentary with the police. He smells of alcohol. He burned one of the police officers, or almost burned one of the police officers with his lighted cigarette. He was so intoxicated, the police officers did not believe that field sobriety tests were going to be able to be performed because he was so argumentative and offensive, and it was very obvious to the 2 police officers that he was under the influence immediately. So I don't think that there was any issue as to the probable cause for his arrest. And Mommy v. Weisner, if I am citing the case correctly, that deals with identified citizen informants. The case law, or the case stands for the proposition that the police can arrest based on an identified citizen informant's observations, and this clearly was an identified citizen informant observation, but it was corroborated as soon as the police arrived at the location, found him in the car with the same license plate and the same identification of the car that the 2 young ladies reported. So I don't think there's really any question whatsoever that there was probable cause to arrest him. The line of sight is not an issue. Nobody got out of that vehicle. There was nobody else in the driveway. There was nobody in the vehicle when the police were speaking with Mr. Stultz. It wasn't until trial that 17-year-old Austin Campbell materializes that for the first time there was an allegation that there was somebody else in the car. But if the court views the testimony and the arguments of counsel, it's quite clear that Austin Campbell was not in that car. As it relates to the alleged prejudicial video, the video is what it is. It speaks for itself. But certainly the probative value of that vehicle wasn't substantially outweighed by the danger of unfair prejudice. It simply is an indication, a video indication of the intoxication level of Mr. Stultz on this particular occasion. There was also a booking room video that didn't get showed to the jury that maybe would have fallen into the category of unfair prejudice, but as indicated, that was not shown. As to jurors' questions about operation, maybe they did have a question. They did have a question about operation, and the judge read the definition of what operation was, and they came back with a guilty verdict. And as it relates to the manifest weight, I think if the court views the transcript of the proceedings and the arguments of counsel, it's pretty clear that the manifest weight argument proffered by the appellant is a red herring. Thank you.
Thank you, counsel. Counsel for the appellant, you have 5 minutes for rebuttal.
Your Honor. Your Honor, again, with regard to the prejudice, I was urged the court to listen to the recordings of this trial. I think that the prejudice comes through far, more than a simple reading of the transcripts. I don't think that you can see or, understand exactly what happened without listening to those recordings. That said, Your Honors, I would again urge the court to consider that I understand that rulings have consistently been that if an identified witness calls in, identifies herself, that those tips are deemed reliable. I understand that. However, even assuming that Mrs. Entwistle's statements are accurate and credible, she again could not identify the driver of the vehicle. This is a Cadillac Escalade ESV. My client owns a limo business, and all the windows on the back of the vehicle are tinted extremely dark as such. And Miss Entwistle made no qualm about it that she did not see the driver or the number of occupants at trial. Again, even assuming that her tip is credible, the operation of the vehicle was still not witnessed by my client. All right, there's circumstantial evidence. I understand that he's in the vehicle, but again, the door to the home, the garage door to the home was open, the lights were on, and the officers made little to no inquiry as to who was in the home. The state does point out that in its brief that he was questioned about who was in the home. I think that was unclear. By watching the video, you can hear the dash cam video. You can hear those exchanges, and I believe that my client was not clear about who was in the home or who possibly would have been driving at that time. With regard to the comment that the state made with burning an officer with a cigarette, there was comments made by Officer Tibbetts that my client did brush against him with the cigarette. It wasn't that he was, again, attacking him in any way. Sorry, 1 second here. With regard to the unfair prejudice of the video, again, Your Honors, the state elected, I think, at some point to not show that booking room video because, as the state pointed out, it probably would have been unfairly prejudicial. Again, I urge the court to consider that the cruiser cam, the rear-facing camera in the cruiser had no probative value. Again, in light of the fact that we offered to stipulate and the fact that the officer's testimony clearly established that Mr. Stultz was intoxicated at the time, again, there was no reason to show the video, and there's certainly no reason to show the video to that length. My client basically repeats himself several times in the back of the vehicle. The comments that were made were made and apparent in the first minute of that video, and the court continued to let that play. Despite my objection, I believe I made at least 3 objections to that video playing or continuing to play even. And the trial court simply ignored those objections and overruled them and permitted the video to play. When it came to playing the booking room video, the court was was prepared to play the booking room video and urged the state to play the video, or at least indicated it was open to playing the video despite my objections. And Mr. Rulebach declined to show that video at that time. Overall, Your Honors, I would urge this court to at least consider that the proceedings in this trial were prejudicial and unfair to my client. My client, again, was in his driveway. No operation of the vehicle had been witnessed by my client. The only circumstantial evidence that was there was based on the responding officer finding, Lieutenant Tibbetts, the responding officer, finding my client seated with a door ajar in his own driveway, listening to music in the car. With regard to the vehicle running, Officer Tibbetts' testimony was, I believe, flawed, as the record will show that Officer Tibbetts, during the suppression hearing, clearly testified that Mr. Stultz reached towards the ignition and turned the vehicle off, removing the keys from the ignition. This proves to be a falsehood, solely based on the fact that the vehicle that my client was in does not have keys. It's a fob system with a push button start and stop, and I believe that'll show that it was flawed in his testimony. Additionally, with regard to the two responding officers, the one responding officer was stopped to speak with the witness, and Lieutenant Tibbetts continued on to the house. They did testify that they could see the vehicle. However, Lieutenant Tibbetts, at the time that he arrested my client, had only spoken to dispatch and had the comments relayed from the witness to himself, and had no identification of my client driving the vehicle. Solely
Hey,
that.
Counsel, unfortunately, I need to let you know that you've used your rebuttal time today.
Okay, Your Honor, I would thank you and ask that this court consider finding for the appellant in this matter.
Thank you both for your oral argument today. The court will take the matter under advisement. We will issue a written decision which is sent to all parties to the appeal, as well as posted on the Ohio Supreme Court website, which you can also link to through the 9th District Court of Appeals website. We are adjourned